Ayanda,
Hi, Arif.
listen, I haven't received any apologies. You?
No, nothing from my side today.
Yeah. All right. Okay.
Oh, okay, sure.
Good morning, all. We're just waiting for the chair to log on. Thank you.
Good morning, honorable members. My apologies. I think there was a technological challenge. Thank you, Honorable Mylem. I didn't have this, but it's okay. I'm finally in. Good morning, everyone, including the presenters. I'm trying to augment my network. Later on, I think at about 10 o'clock, I will have been out of load shedding. Can you, Ari, place the agenda? Yes. Do we have any apologies?
Morning, Chair. Just one apology from Honorable Graham Mare, who's attending the PC on planning, monitoring, and evaluation, Chair. That's the only apologies received, Chair. Thank you.
Okay, all members and everyone present today, we are dealing with the oral submission based on request by those who had written submissions, and then subsequently we'll deal with standing matters with regards to public hearings only, and probably what could be early next year that may require the attention of the committee without any delay, so that we save the time that was consumed. Who is number one, Ari?
The National Nuclear Regulator, Chair. NNR.
NNR. The time has not changed. It remains the same that you were given. If you are not, we'll help you. Can they connect?
Good morning, Chairperson. Good morning to the members. Yes, we are connected. I just want to check with Ari. Shall I share my screen or you are projecting?
No, I was informed that I must give co-hosting rights to Kathleen Brink.
Oh, Kathy will project. Thank you.
Yeah.
Honorable Chair, while we are waiting for the presentation to show up on the screen, my name is Dideb Kokomo and I'm the CEO of the Regulator. I just want to greet you and the honorable members of the committee, and greetings as well to all the other guests on this call. Kathy?
Is Kathy in the meeting?
Yes, she is on this call. She's a co-host. While we are waiting for her to put up the slides, Honorable Chair, I would just like to take this opportunity to appreciate the chance that has been given to us to provide some inputs that would assist the committee towards the finalization of the amendments to the NNR Act. And we are supportive of the legislative process to amend this act. It has been in operation for 23 years without any amendments. And during this period as a regulator, we have identified areas that require improvements in order to enhance effective regulation of the nuclear industry, as well as aligning our practices, with international practice, as well as recommendations that have been made during international peer review missions under the auspices of the International Atomic Energy Agency. So over the past few years, we have proposed several amendments to the Department of Energy then, and now the Department of Mineral Resources and Energy for their consideration. And we are happy to see that the DMRE has, for the most part, adopted the proposals that we have made. And so we are pleased that the legislative process has progressed to the level of the portfolio committee. And as a regulator, we are supportive of the bill that has been presented to the portfolio committee. Kathy, I'm on slide number 3. And nevertheless, Honorable Chair and honorable members, we have identified some areas on the bill that has been published that require a bit of improvement in order to provide regulatory certainty. Next slide. So our proposals for these improvements and for the amendment of the Act in general are aimed at improving and addressing, amongst others, these matters to ensure that the provisions of the Act are consistent with the Constitution, also that the provisions are consistent with the Public Finance Management Act. We would also like to clarify the role of the NNR board with regards to the appointment, of the Chief Executive Officer, as well as increase the term of office of the Chief Executive Officer from 3 to 5 years in order to create leadership stability and align with the terms of other Chief Executive Officers of other regulatory bodies in South Africa. We'd also like to clarify the powers of the inspectors, provide clarity with regards to transfer of authorized actions where an authorization from the NNR already exists. The transfer process thereof, we would like to clarify that, and we make provision for prescribed technical services which require nuclear authorizations. We also like to align certain terminologies that are in the law and the definitions with the practice that has been adopted, with the current international thinking and the recommendations of both the IAEA and the International Commission on Radiological Protection, the ICRP. Chairperson, so I will go straight into the areas of improvement, and here we start with a long title. It is projected on the screen, and you will see that we have highlighted the word nuclear in the long title. Our concern here is that the inclusion of nuclear in the long title, it is limiting the scope of application of the Act, as it does not include safe rehabilitation and decommissioning of facilities that are handling naturally occurring radioactive materials. So our proposed solution is that the word nuclear in the long title be deleted. The next area of improvement is in the definitions, where the definition of activities has got the word radioactive written into different forms. And initially, when we considered this, when we looked at this definition, we had seen it as limiting the application of the Act, as it does not cover activities related to irradiating apparatus. But subsequent to our submitting comments to the portfolio committee, we had further engagement with the DMRE, where clarity has been provided and the department is considering our inputs. But be that as it may, we believe that for consistency purposes, in the entire bill, we recommend the use
Sorry, ma'am. Can someone in your background please lower their voice, because we hear a little bit of background noise.
Thank you, Chair. I hope they are quiet now. So what we are proposing, Chairperson, is that in the entire bill, we use only one version of radioactive, and that is radioactive as one word without the dash. Honorable Chair, then I'll move to the next area of improvement. It is still in the definitions, and it's related to the definition of clearance. While I have highlighted radioactive, we have dispensed with that. The next issue is the highlighted word right at the end of that definition, that being activities. Our concern is that this definition is limited to authorized activities and it excludes facilities. So we recommend that the word activities be replaced with facilities and activities as part of the definition, because of course the facilities are regulated. The next area of improvement, Honorable Chair, is still in the definitions and is the definition of discharges. And here again, we highlight the word regulate nuclear in the definition. And our concern is that using nuclear facilities limits the application of the Act, and therefore the inclusion of nuclear automatically excludes the norm and other radiation facilities. We therefore propose that that word be deleted. Next, Chairperson, is the definition.
Recording in progress.
Next is the definition of dosimetry services provider, and this definition is not used in the bill, and we recommend that it be deleted. Next is still in the definitions, and it is the definition of facility. We have highlighted the use of some, an example that is given such as. This definition as currently drafted has the potential to create uncertainty with regards to the types of facilities that are to be regulated, because it excludes any, and the inclusion of the specific reference to uranium mines may cause confusion in the interpretation of this definition, because it suggests exclusion of other uranium mines, other mines, even if it happens that they have an element of radioactive material in them. So we recommend that some mining and raw material processing facilities, such as uranium mines, be replaced with facilities where mining and processing of radioactive ores are carried out. So that will be all encompassing. If you are mining thorium, you are mining a radioactive ore, and the definition as we propose with that replacement will then cover all the facilities. Chairperson, still in the definition, the next area of improvement is that when we looked at the amendment bill, we found that non-ionizing radiation is not included. There is no definition for non-ionizing radiation. And it is necessary that we have this definition so as to clarify the extent, the definition of radiation which is introduced by the bill. And therefore, we recommend that for purposes of clarity, the definition be included as such. As non-ionizing radiation means all radiation and fields of electromagnetic spectrum that do not normally have sufficient energy to produce ionization in matter, characterized by energy per photon less than 12 electron volts, wavelengths greater than 100 nanometers, and frequencies lower than 3 times 10 to the power of 15 hertz. Then the next area of improvement is on the definition of nuclear accident. The current bill has got a new definition of nuclear and radiation accident. And therefore, we believe that the definition of nuclear accident may not be necessary, and we propose that it be deleted. The next area of improvement, Honorable Chair and members, is the definition of nuclear and radiological emergency. Our concern here, when we initially considered this definition, we kind of saw it as limiting the application of the Act, as it does not cover non-ionizing radiation. And subsequent to us submitting comments to the portfolio committee, we've had further engagements with the DMRE, wherein we've provided further clarification, and the department is considering our inputs, and we do recommend that this term be paraphrased to read nuclear and radiation emergency. Then the next area of improvement is in the definitions, and it is the definition of period of responsibility. It is flattered on the screen. We believe that it is cumbersome, and revision may be necessary just to make it simpler, clearer, and understandable to the people that this law will be relevant for. So we propose that the definition of period of responsibility be simplified to mean the period beginning on the date of coming into force of the relevant authorization and ending on the date on which the regulator gives notice in writing to the holder of the authorization, informing them that they are relieved of further responsibility. Honorable Chair, I'll move to the next area of improvement. It is still in the definition, and this relates to the definition of the pre-construction activities. I will read from that last sentence where it says building of diagram wall and excavation and clearance of bedrock. This is inaccurate technical terminology, and it needs to be corrected, and we replace diagram with diaphragm, and we replace off with to, because of course you cannot clear the bedrock. You can't excavate and clear bedrock, but you excavate and clear to bedrock. Next, Honorable Chair and members, is the definition of prescribed. And the definition currently means prescribed by regulation made in terms of Section 47. Our concern here really is that we think this definition is not necessary at all, as prescribed has a conventional meaning in South African law. But in addition, there are other sections of the Act that require prescription of regulations. For example, in terms of Section 6, subsection 3, Section 36, subsection 1, and Section 38, subsection 4. So we propose that the definition of prescribed be deleted. The next area of improvement is still in the definitions, and it is the definition of site evaluation. as currently crafted, this definition limits the application of the Act as security aspect of site evaluation is not included. And an assessment of the suitability of the site from a security perspective is a fundamental aspect of characterizing sites for new nuclear facilities. So we therefore recommend that the definition be amended to read nuclear or radiation safety and security of facility and activity on that site. The next area of improvement is related to clause number 2, and this is the heading. We initially considered this heading as limiting, but subsequent to submitting the comments, we have had further engagement with the DMRE, wherein clarity has been provided, and we no longer propose change. So no change is proposed to this heading, but we just needed to flag that this morning so that we clarify the committee that we are no longer concerned with that heading. Still in clause 2, the next area of improvement is clause 2, subsection 1, line C, which reads, subject to subsection 2, this act applies to, there's a long list, and then radiation sources, including devices in which they are incorporated. So when we considered the bill, we saw this provision as limiting the act, as it does not cover the activities related to the irradiating apparatus. We've had engagement with the DMRE since we submitted the comments to the committee, and the department is considering our input, which was to recommend the inclusion of irradiating apparatus to clause 2.1c. The next area of improvement is clause number 5, which is about the object of the regulator. And subsection A reads to provide for the protection of persons, property, and the environment against the harmful effects of radiation associated with nuclear facilities and activities through the establishment of safety and related security standards and regulatory practices. The inclusion of the word nuclear in this section is limiting the application of the Act, as it does not address the facilities or activities that are regulated by the Act, and therefore we recommend that nuclear be deleted from this provision. The next clause that we propose improvements to is clause 8. And this is about the board of the regulator. And we indicate section A, which talks to the directors that are appointed by the minister that represent different formations. And our concern is that this clause, it provides for the board to be comprised of stakeholder representatives, yes. And in most cases, the stakeholder representatives come to the board with embedded conflicts of interest. And the stakeholder representatives' argument is that they do not owe the fiduciary responsibility to the regulator, but to their constituencies. This clause, therefore, our view is that it exposes the regulatory decisions to be influenced by views and positions of constituencies instead of safety assessment of an application that is received by the NNR. And so we propose that, in order to ensure the credibility of regulatory decisions, removing the stakeholder representation and constituting the board with independent board members, similar to other regulators. And so we recommend that the text in 8.4 be revised to reflect that the board consists of no less than 7 and not more than 11 non-executive board members who collectively must have adequate technical, regulatory, legal, and financial experience. Honorable Chair, then the next area of improvement is on clause number 20, subsection 5. This provision may create an impression that all vessels require a certificate of registration, which is not the case because we have other vessels that require a nuclear vessel license in terms of section 20, subsection 4. We therefore recommend that in order to be clear, this clause be paraphrased to read, no vessel other than those listed in subsection 24, which has on board any radioactive material capable of causing nuclear damage, may A, anchor or sojourn in the territorial waters of the Republic, or B, enter or leave any port of the Republic except under the authority of a certificate of registration. I will move on to the next area of improvement, which is clause number 21. 21, subsection 4, which refers to section 20, subsection 5 and subsection 6. And we initially thought that this cross-referencing to subclause 25 was incorrect. But on further consideration, we think it can be rephrased in order to make it clearer. We therefore propose that it reads as follows. The regulator recommends, that section 21.4 should read as follows, that any person other than persons mentioned in section 20, subsection 5 and subsection 6, operating a vessel which is propelled by nuclear power or which has on board any fissile material or uranium hexafluoride and wishing to A, anchor or sojourn in the territorial waters of the Republic, or B, enter any port in the Republic, must apply to the Chief Executive Officer for a nuclear vessel license and must furnish such information as the board requires. I will now move on to clause 22, which the bill proposes to replace may with must, to say the Chief Executive Officer must direct that the applicant for a certificate of registration, certificate of exemption, authorization to design, or authorization to manufacture. And then it lists the actions that they must do. So we believe that the inclusion of the word must will defeat the principles of regulating facilities and activities commensurate with the risk that is associated with those facilities and activities. And we believe that a graded approach is required. So as an example, if you have a ton of material in respect of which an application for a certificate of exemption relates, which will be used in a manner that does not introduce in any way pathways that are not of regulatory concern, should not be subjected to the notice and comment procedure due to the low risk that such an activity poses. But with this new phrasing, such a user of that material will then be required to go through this process. And we think that it is unnecessary red tape by the regulator. It is not warranted and it is not good regulatory practice. We therefore recommend the retention of may as a discretion that should be considered so that the regulator can decide on a case-by-case basis, taking into account the risk associated with an activity in line with the graded approach. Honorable Chair, the next area of improvement is clause number 25 that talks to transfer of authorization. And on the top line, that is how it currently reads. And we believe that there's a need for clarity. And we propose that we harmonize subsection 1 and 2. And once we have harmonized, then we'd delete subsection 1. So we also recommend that responsibility be replaced with authorization. And so clause 25 would read, as follows. An authorization holder may not transfer an authorization for regulated activities to another person or entity without the written permission of the Chief Executive Officer, subject to approval by the board. And then subsection 3 would read, a person or entity to whom an authorization.
Now, sorry, you are on my injury time of my 3 minutes.
I am.
Yes.
Chair, I'll speed up. I only have 3 more.
Yes, in 3 minutes.
In 3 minutes, okay. So a person or entity to whom an authorization for previously regulated activities is to be transferred must apply to the regulator as prescribed. Then, Chair, I will move very swiftly to clause 47 that deals with making regulations. Under the regulations under section 36 subsection 1 are made on the recommendation of the board and not after consultation with the board, as this is necessary to ensure regulatory independence. And we therefore recommend that clause 47 subsection 1 be amended to exclude the regulations in section 36 subsection 1. Next, Honorable Chair, is clause 49. And this clause talks to if the minister rejects the recommendation of the board as contemplated, and it lists section 28, section 29, subsection 1 or subsection 2, section 36, subsection 1, and section 38, subsection 4. We believe that the addition of section 36.1 and section 29.1 water down the independence of the regulator to develop and recommend safety standards and regulatory practices, and to make the mandatory recommendation on financial security. And therefore, we recommend that references to section 36.1 and section 29.1 be deleted from clause 49. And in conclusion, Chairperson, those were all the areas of improvement that we have identified. We remain available to assist the Portfolio Committee as well as the department to finalize the bill as and when you require our assistance. And we would like to send a message out that you are free to confer with us on any issue which may require clarification or appreciation of the practical implementation of the proposed clauses. And I would like to take this opportunity to thank you, Honorable Chairperson and honorable members, for the opportunity to make this presentation this morning. Thank you, Chair.
Thank you, NNR. Any questions of clarity, honorable members? Going, I see the hand of Honorable Treza and then Honorable Mailam. Any other hand? 1, 2. Okay. Honorable Treza, then Honorable Mailam.
No, thank you, Chair. I might be taking the committee backward on these matters, but I need clarity here. The first one is whether we're able to access the proposed changes from the presentation that we've just had as members, so that we are able to can peruse, because remember that I've just arrived. And I would like to also ask whether we are at a point where we can ask whether there is a legal advice to the proposed changes, so that because it's just technical language that should be changed for, even though we're not told what prompts the changes per se into this thing. So that's why I wanted to ask you whether we're at a point of legal advice to the committee, so that we know, for instance, that when you talk about international thinking, what are you talking about? When you talk about aligning with international thinking, you know, in terms of the improvements that you are proposing and international practices. what are you talking about, so that we are in one accord. We don't leave each other, because this is such a technical language, and these are cosmetics that we seek to propose, but it's not a language that we are all omniscient to. Yeah, it's not an easy language. So I just wanted to ask whether the presenter was serving as a legal advisor into that from Parliament, in terms of the advisory measures that he is proposing, so that at least he takes us with, in terms, because we're not in part of the committee, even we don't know at which point is the bill and so forth. Thank you very much, Chair.
Okay, Honorable Milam.
Thank you, Chairperson. And Chairperson, while I have sympathy for Honorable Keza, we've had this bill in front of us for a while now, but I do have some concerns. I don't think this bill is ready for this discussion yet, based on the inputs from the NNR. They're amending things that the bill does not amend. And to give you an example, if you have a look at clause 22, the amendment that the NNR are proposing is not actually amended in the draft bill. So they're proposing an additional amendment that hasn't been consulted on, or there hasn't been any participation on to this point. I have a concern with that. I think that this bill is premature, and that the NNR should have been liaising with the DMRE to a much greater extent before this bill came to Parliament. But Chair, I do want to highlight a couple of queries, if I may. The first is on the slide where the NNR proposed an amendment to the long title of the bill, or the objects of the bill, sorry. And they say with safe rehabilitation of or decommissioning of nuclear facilities, and they want to delete nuclear because it doesn't include norm activities and facilities. So I would argue that rather than deleting nuclear, adding and norm facilities with a full breakdown of what norm actually stands for. The reason for that is otherwise the bill is way too broad. It would basically give them associated costs with rehabilitation or decommissioning of any facility, whether it's nuclear or not. So I have a concern there, and I'd welcome the NNR's input on that. And then I also have a concern with the amendment to clause 8. And here we're talking about the composition of the board, and the NNR objects on the basis that stakeholders come with their own inherent biases and agendas, and they say that this is not necessarily the agenda or mandate of the NNR. And I'd welcome the NNR's input on how they propose to get a diversity of opinion from the union areas, the labor, from civil society, et cetera, and various stakeholders that are included in the board, if everyone is in lockstep with a vision and mandate that is promulgated by the minister, or by the NNR. I'd really welcome how they propose a diversity of opinion and views, if that is their kind of criteria for being a board member. Thank you, Chair.
Thank you, honorable members. No, honorable Keza, this is NNR.
Apologies. Good morning. My hand is up.
But I checked, it was not there. Okay, Honorable Malinga.
Hence, I am saying apologies, Chair. Good morning. I was battling this morning with the link and all that. So, good morning to yourself, members of the portfolio, our guests on the platform, and our committee staff. Chairperson, mine is just one. One, maybe as legislators, we need to understand how the bill gets to be sent to us. The department has sent a bill to us for amendment, amending certain sections that the NNR has just explained and said on the definitions and all that. So for us to say whether the bill is premature or not premature, I don't think it's correct, but we say the bill is premature, should be reversed or should be turned back, but we still ask them questions. I don't think that it's up to us to say what bill the executive should bring or not bring. We have a bill in front of us, and we need to understand what this bill seeks to achieve, and we achieve that. That's all I wanted to say, Chairperson. Thank you very much.
Honorable Kaiser, I think that it is enough to have courtesy to you. The bill was sent to the committee. The department, as usual, presented the bill to the committee, and we just asked questions like we do of clarity. And then it was agreed by the committee that because of the nature of the bill, it is mostly an enforcement bill in terms of what is proposed as clauses, or a compliance bill. There would be no need for public hearings because in the main, it seeks to give authority to the entity. Subsequently, we then only agreed that there will be written submissions. The department is coming next week to present its response on the proposed amendment on this bill. And after that, we will then have a process of the committee deliberating on the proposed amendments of the bill. For instance, the department may come next week and say, on this proposed amendment, we are amenable and we are in agreement with it, or no, we cannot agree with this proposed amendment. Here are our reasons that we don't agree with them. And then subsequently, we will then have the deliberations as a committee. In those deliberations, Parliamentary Legal Service will be represented, as well as the Office of the Chief State Law Advisors, to now look at the areas of legality that are contained, including on what we may agree, or especially if we may agree, whether what we seek to agree on is legal or not. So that process of legal advice will only come in when we deliberate on the contents of the bill. For now, we are listening to different public opinion on the proposed amendments, and we don't have to agree with them. We just have to note what they are saying, and we then ask questions of clarity. We will then make our views, and I want to appeal to all of us, honorable members. Let's refrain from this thing of wanting to abuse the platform and argue our own things when we have invited people in the committee. Whether this bill is early or not, whether we have to ask these questions or not, it is us, when we go to the committee, we deliberate, we then say, we don't think. I really appeal to us. Can we hold our views and ask clarities that will help us when we express our views as members of the portfolio committee? For now, let's seek questions of clarity. For an example, do you mean this? Do I understand you when you say this? This is what you mean. So that when that person gives you an answer, no, this is what I meant. At least when I go and deliberate, I know what this person was actually saying. Whether I agree with this person with what he's saying or not, that's a different matter, because we are not here to disagree with anyone. We are here to listen to the views of what the people are saying. So can we focus on the people who have invited and then hold our own views and opinions for the period where we will be deliberating on the bill? Then we will express our views freely. No one will be curtailed or limited to say anything. So can I request that NNR respond on issues that relate to what you need to clarify as what you mean or what you understand to be the case. The last thing, I will make this comment later on, because I think we should not deny this fact. There is something I raised yesterday. I'm expecting NNR that, like they said, they were part of the proposed amendments. They made this request and the department decided to follow suit. I'm expecting NNR that next week, when the department comes to present on the proposed amendment, it will be part of the department and say yes on this one. So my first thing I would say on this one, without doubt, NNR, when you finish here, these things that we are saying now here, take them to the department, come back with the department. In the same thing, we can't have PASA making a presentation here when the bill that is proposed by the department is giving authority to PASA. We expect all of you to come here and say, this is what you are suggesting. Yes, it's good to help us, to guide us, to say this is what is the meaning. But like I said yesterday, I fear a situation where people disagree somewhere else and then they come and I'm not saying you are disagreeing with the department, but it will happen one day. People disagree somewhere there. They then say, no, we'll get it in the portfolio committee. I think for me, there is a system that is wrong and it requires us as members of parliament not to, in my view, not to allow this trend to continue forever. But can I give you an error to respond on the specific matters with regard to your submission?
Thank you, Honorable Chair, and I would like to appreciate the inputs from Honorable Gasa Maileham and Memalinga. Honorable Chair, I'll start with the long title where the deletion of nuclear suggests that it will just be too wide and be all kinds of facilities. I'm happy to indicate that the bill defines facility and it means nuclear facility, irradiation facility, some mining and raw mineral processing facilities such as uranium mines, radioactive waste management facility, and any other places where radioactive material is produced, processed, used, handled, stored, or disposed of on such a scale that protection and nuclear safety is required. Protection and safety is required. So facilities are defined. And then I will go to clause 8, where the question has been asked, how do we ensure diversity of views? And as we have indicated on the proposed phrasing of the clause, that we use the word collectively there, where we indicate the board consists of the number of board members who collectively must have certain kind of expertise, and we believe that this will show the diversity of views. And Honorable Chairperson, the last matter that I should respond to is on clause 22, just to indicate that the current act, number 47 of 1999, actually uses the word may. So the must is a new proposal that we are indicating to the committee that maybe we shouldn't go that direction, that we retain the word may, which is in the current act. Thank you, Honorable Chair. Those are the notes that I made of what I need to respond to. Thank you.
Oh, sorry, I don't say I'm muted. Ari, who's next?
Kubak alert, Chair.
Yeah, Kubek alert, and then it will be outer. Are you alert, Kubek?
Good morning, Chair. Yes, ready for you.
Okay.
So good morning, Chair. Good morning, honorable members. Good morning, colleagues and members of the public. Thank you very much for this opportunity to present. I will try and see if we can catch up a bit of time because I see we're a little bit behind. The Coburg Alert made a submission, which is on the screen at the moment, and I'm not going to be going through that. I'm going to be doing a presentation to you. And firstly, tell you who I am. I've been a member of the Coburg Alert for about 14 years. I believe active citizenry is important, and I believe civil society is important. I've never been paid for the work that I do, not by anyone, not even by the CIA. And I'm not currently the spokesperson for the Coburg Alert Alliance, but I've been asked to speak to some aspects of the submission because of my familiarity with the legal aspects around this whole thing. So I think it's a good place to start to ask, why does the NNR Act exist? What is the purpose of the Act? Where did it come from? And it originated from this Convention on Nuclear Safety, which was an international treaty, which was signed by South Africa in 1994 and ratified in 1997. And you'll notice that the Act of 1999 was created 2 years thereafter. So we'll come back to the slide, but basically it put an obligation on each contracting party, which included South Africa, to establish a regulatory body entrusted with the framework referred to and take steps to ensure it's separate and it's an independent body. So the Act of 99 was created, and again, always important to focus on the purpose. The purpose of the regulator is to provide for the protection of persons, property, and the environment against damage through the establishment of safety standards and so on, and to exercise regulatory control. So the primary object to bear in mind is it's for the protections of person, property, and the environment. So I think we agree on many things. All of us, doesn't matter what side of the views we come from, we all agree we want our families, our children to be safe. We agree that it's our constitutional right to have a safe environment, and we believe the regulator has to be effective in carrying out its mandate. And in order to be effective, it must be sufficiently funded. It must make decisions based purely on scientific reasons and must have the scientific expertise to make those decisions. And it should be free from political interference in its decision making. And also, I just wanted to express very strong agreement with many of the points that the CEO of the NNR just made in the previous presentation. And a lot of them were aimed at ensuring the independence and the strength of the regulator. And I certainly support all of those and will be making some additional points. I do want to mention that I disagree with one point made in the previous presentation, that there should not be a diversity of views on the board. I think there's strength in diversity of views. At the moment, there are many civil servants on the NNR board, and those civil servants have actually signed performance agreements to say they'll loyally execute government policy. So it's important to have a balanced voice there. It's not as if one representative of Labour or one representative of communities can sway the entire board unless they've got a very good point they make. And if this comes to a vote, obviously those two members, the Labour and the community, can simply be outvoted if they are holding an unreasonable point of view. So I strongly disagree with that. I think diversity of opinion is strength. There is strength in diversity. Right, next slide. So I'm not going to go through this in too much detail, but what I do want to do is just glance at the sections which grant powers to the minister. So the minister can appoint board members, and there are the sections. I won't read them out. He can also appoint the chairperson and the deputy amongst the board. So the board does not select its own or vote for its own chair or deputy. The minister appoints a closed door panel to shortlist board members, certain of them, and the makeup of that panel is not public. There was an attempt to do a PIA for it, and the minister refused, saying it's up to him to decide, and he doesn't have to tell anyone who those panel members are. The minister can dismiss a board member. He can also appoint the CEO, which creates a little bit of a strange situation when the CEO should be answerable to the board. But in fact, it is the minister who appoints the CEO. It can also discharge the CEO. And I think that's a certain, there's some difficulties with that. then particularly, and I think the previous presentation touched on this as well, the minister can override any decision of the board. And that includes setting fees, categorizing what a nuclear installation is and isn't, setting regulations about safety standards and regulatory practices, and also regulations, requirements for an emergency plan. So that's all described in section 49.2. And this is a concern in terms of the independence of the NNR. If the NNR, given its wisdom and technical staff, makes the decision that a certain regulation is required or a certain emergency plan is required, it's disturbing to think that a minister, without the technical staff and without the expertise, can simply override that decision. So after 2011, a lot changed in the nuclear industry, and it caused a careful relook at how regulatory systems were set up. And I think it's important to learn from that. I was lucky enough to be flown to Japan in 2012, where I saw firsthand various things. That's the border on the top left to the exclusion zone, which is a 20-kilometer circle around the plant where no one was allowed in. Those are trucks which are trucking out radioactive soil. Thousands of tons of that was trucked out. The bottom is the housing that was built for the people who had to evacuate. The government had to build thousands of houses. And we were shown this in an attempt to generate sympathy for the poor Japanese people who were forced to live in these houses with gas, electricity, running water, and so on. Coming from South Africa, it was a bit tricky to feel that level of sympathy. But the point is, it showed the need, that there might be the need to build a phenomenal amount of housing very, very quickly. Top right is a Geiger counter, which we monitored all the way to see how serious a radiation area we were in. But anyway, let's cut to what's important, and that's the lessons to learn from Fukushima. So there was an official report, and there was many media reports about this was the reason, that was the reason, the earthquake was the reason, the tsunami was the reason, the unexpected size of the tsunami was the reason. And of course, natural events happen. But let's look at the official report that was submitted to the Parliament of Japan, which they call the Diet there. So Diet is equivalent to the Parliament. So under conclusion, the report starts. The TEPCO Fukushima nuclear plant accident was the result of collusion between government, regulators, and TEPCO, and the lack of governance. So the actual cause was a regulatory failure. That was manifested by the tsunami and by the earthquake, but it was a regulatory failure. Now, you might remember from a previous slide that Japan had signed the Convention on Nuclear Safety that said the regulator must be separated from any department who promotes the use of nuclear power. So again, the underlying bit, they believe that the root cause of the Fukushima disaster were organizational and regulatory systems that supported faulty rationales. So those organizational and regulatory systems are solidly the responsible of Parliament, which is why I'm talking to you today. So the TEPCO report, not the TEPCO report, the official government report of Fukushima made several recommendations. And you can see number one there is that the regulator must be independent from organizations promoted by the government. Now, in fact, Japan was already obliged to do that, but they didn't implement it. And because of that, the regulatory framework was such that the tsunami resulted in such a wide-scale nuclear disaster.
Chair? Chairperson?
Hello? Are you...
I apologize for interrupting.
Yes?
I apologize for interrupting, but it appears that the screen that we're viewing is the submission and it's not Mr. Becker's presentation.
I noticed that it's also static, but I thought it's based on the written documentation. I wanted to... It's almost at the tail end now.
Thank you, Chair.
Okay. We must go towards wrapping.
Thank you. Thank you for pointing out that. I think I have corrected it. If you can maybe just confirm that. All right, let me carry on.
No, continue, sir.
Okay. So you should be seeing the presentation screen now. And what happened after 2011 is the International Atomic Energy Agency visited every country in across the world to make recommendations. And that's called the Integrated Nuclear Infrastructure Review. And they sent a team out to South Africa, and they made several recommendations in 2013. And this was an interesting line from it. Considering the Minister of Energy is in charge of the promotion of nuclear energy, and given the structure, the designation of the board members and the process to approve the NNR's budget, the team is of the view that there's no adequate separation between the regulatory functions and promotional activities, thus calling into question the effective independence of the NNR. So this is a very serious Fukushima, but it has not been implemented. And also surprising to see that the presentation from the NNR has not brought up this issue. The IAEA visited again in March 22, and they pointed out in their 22 report that some of their previous recommendations had not been implemented. And bear in mind, the recommendation is the strongest word that can be used by the IAEA. They don't, contrary to what some believe, they don't control the country, they have no regulatory authority, they don't issue permits. That is the responsibility of the NNR. They only make recommendations, and their recommendation in this case was that the incorrect minister is in charge of appointing board members and in charge of the budget, and is far too much in control of the NNR. And in their own words, this calls into question the effective independence of the NNR. So I said I would come back to this slide. And this was why we created the NNR, if you remember from earlier in the presentation. And here I'm highlighting a particular thing about our international commitments. Each contracting party shall take steps to ensure an effective separation between the functions of the regulatory body and those of any other body or organization concerned with the promotion or utilization of nuclear energy. So that's very clear and quite broad. And I think there's absolutely no doubt that the Department of Mineral Resources and Energy is promoting the use of nuclear power. We see that in the press all the time. There's also moves that Eskom should be moved under the DMRE. That's been proposed and perhaps in motion. And if that does occur, then the DMRE is also concerned with the utilization of nuclear power. So this was the concern way back when this contract was, this treaty was signed, and it is under international law the responsibility of Parliament to implement the terms of this treaty, and it's the responsibility of the President. And so far, it appears that responsibility has not been fulfilled. So where else could we see how this could be an issue? This is a performance agreement signed between the Minister of the DMRE and the President. It was signed in 2019. And it contains various targets and what we would call in the corporate world KPIs, key performance indicators. And for example, one of the targets here is that the Koeberg nuclear plant life extension must be completed. Now, this means that there's a minister who's in charge of dismissing and appointing the CEO and board members who's made a commitment that they will extend the life of the nuclear plant. So this potentially holds up a flag of a potential conflict of interest. It's not just international. In the 2013, the Department of Energy commissioned a study, and I can provide the documentation that shows this. It was actually presented to this very committee, I think 2016 perhaps. And in 2013, this company, Nathan Gift, was asked to do a 1-month study on the effective independence of the NNR, obviously in response, it's 2013, in response to the IAEA recommendation. That study cost R500,000. It took 4 weeks to complete. I haven't managed to find that study in the public domain. I'd be most interested in reading it, but they did present it to Parliament, and they said the output of the study was that there needs to be effective separation of the NNR from the Minister of DOE, which is now DMRE, and a migration to a Department of Environmental Affairs that is not responsible for the promotion of nuclear. So we've got a treaty signed in 2000, when was it, 1994, that obliges us to make the NNR independent from the minister. We've got an IAEA visit that said there's insufficient independence. It needs to be separated from the minister. We've got an internal study paid for by Parliament for R500,000 that says the NNR must move out from the influence of the Department of Energy and under the minister responsible for the environment. Everyone agrees.
3 minutes discretion over time.
Oh, wow. Okay, already. I will try and keep moving. So this is something that is on the Eskom site, and I'll leave you to draw your own conclusions from this. Countdown to license extension. There seems to be an assumption built into the Eskom thinking, and perhaps that relates to the previous slides I was talking about. This is also interesting. This is the safety case, which is submitted by Eskom to the NNR and also to the public. And Eskom attempted to redact a portion, a large portion of it, and due to a legal process, they were forced to release it. But I showed this to someone from overseas who raised the question, which is an interesting question. Why was the Eskom prepared to show this sentence to the NNR, that technical safety requirements, rigorous safety program, close cooperation? Why were they prepared to show that to the NNR, but keep it from the public? And I won't speculate, I'll leave you to think about that. So if there's a perceived conflict of interest, that's common. We always have conflicts of interest. The point is they need to be skillfully managed. But if that conflict of interest results in a decision or action which is a direct conflict of the purpose of the organization, then we have a problem. What is even more of a problem is if Parliament were to create a system or not to fix the system which has an inherent conflict of interest built into the very structure. And that is what we have at the moment in the NNR bill. I won't comment on this, but this must have been noticed, shall we say, by NNR board members. This is an entirely inappropriate in terms of, entirely inappropriate. So the conclusions about the minister in charge. It's the duty of Parliament to ensure that the NNR aligns with the treaty. It has ratified itself. Change is a simple one, and it's long overdue. It's recommended by the IAEA and by the own internal report commissioned by Parliament. Briefly on a few other points, naval vessels. There is a disturbing trend in this amendment to reduce the power of the NNR. And the CEO pointed that out in her presentation previously. So this exemption of naval vessels is a problem. Any state can just say, this is a naval vessel. And I think you might recognize the name here. And then it's suddenly...
Thank you, sir. Unfortunately, we have to be fair. There are others that are coming. We only dealt with 2 entities. Thank you very much. We will look at how we deal with the final contents, and the presentations are already in the hands of the honorable members. Honorable members, are there any questions of clarity? Going 1, Honorable Mailem. Going 2, going 3. Okay, Honorable Mailem.
Thank you, Chairperson. Chairperson, just one quite simple question, and that is, you talk about the independence of the NNR and that it should be under the Department of Environmental Affairs or the Department of Health. However, the NNR has a very large technical responsibility that doesn't align with environmental affairs or health issues. So my question is this: which countries around the world, where can you point to examples where the nuclear regulatory authority, whatever it may be called in those countries, does not sit under the Department of Energy or a similar entity? Because it strikes me as an odd request. Thank you very much.
Okay, can we get an answer to that?
Yes, with pleasure. An example is Japan. Immediately after the Fukushima disaster and that report that I showed you, the regulator was removed from the influence of what was called METI, the Minister for Energy and Technology, I think, in that country. That was one of the fixes to the system that resulted from that report. I'm not familiar with other countries, Mr. Malham, but I can do some research and I can get that back to you on the side.
Oh, sorry, Arif, can we give in outer? You see the time outer?
Yes, good morning, Chair, and all stakeholders present. This is Brendan Slade here on behalf of the organization Undoing Tax Abuse. Just for some admin housekeeping, I'm going to share my PowerPoint presentation if I can just get a nod whether or not it is being seen. Could I perhaps get confirmation everybody seeing the screen?
Yes.
Okay, 100%. Thank you, Mr. Marlin. Okay, without further ado, just a short introduction of who OUTA is. I would just like to thank the Portfolio Committee for the opportunity for OUTA to present today. This is obviously following our formal submission that we made in October of this year. So a little background to OUTA. OUTA is a civil activist organization. It's the organization Undoing Tax Abuse, is a registered non-profit civil action organization that focuses on exposing government corruption. Sorry, still seeing my screen?
Yes.
I can just confirm, are you seeing the slideshow with a red box?
Yes, we see your presentation is on the screen.
Thank you, 100%. Just where I left off, that focuses on exposing government corruption and the abuse of taxes and public funds through investigation, research, communication, empowerment, and litigation. We are apolitical and rely on public funding to hold those guilty of corruption and maladministration to account. Our vision is a prosperous country with an organized, engaged, and empowered civil society that ensures responsible use of tax revenues throughout all levels of government. Our mission is challenging and taking action against maladministration and corruption, and where possible, holding those personally responsible to account for their conduct and actions. Further to our mission is challenging decisions, legislation, and the regulatory environment as and when deemed as irrational, unfit, ineffective for their intended purpose. In addition to our mission, it's working with civil society and authorities in improving administration and service delivery within all spheres of government. And now we head over to the main topic of today, which is the NNR Amendment Bill. So as a civil action organization, one of our key focus areas and our main concerns are the independence of our institutions. So it is imperative that the NNR is independent. We'd just like to comment that the bill or the act is sound at this stage, but much more can and should be done. And as Mr. Milham pointed out earlier during today's presentations, there is certainly much more deliberations needed in order for this bill to be fit and proper for purpose. It needs to have a sound legal framework around nuclear energy in South Africa, which, as stated previously, it is a step in the right direction. The bill/act needs to be free from political interference, and public interest as far as nuclear energy in South Africa is concerned must always be a priority. It is, once again, I reiterate, a move in the right direction. However, as the previous presenter, Mr. Peter Backer, pointed out, there was a recent report by the International Atomic Energy Agency in 2013, And in particular relation to independence, I just highlighted the relevant section of their report, or one of the relevant findings rather, in 2013, considering that the Minister of Energy is also in charge of the promotion of nuclear energy, and given that the Minister appoints the NNR board and CEO, approves the NNR's budget and promulgates regulations, the INIR team is of the view that the separation between the regulatory functions and the promotional activities is not adequate, thus calling into question the effective independence of the NNR. So we are now in 2023. These recommendations follows a study that was made in 2013. That is a 10-year time span between recommendations made and this session we are sitting in today. You can call it a tongue-in-cheek question, but has Parliament missed the mark? I think the fact 10 years later after these recommendations were made, some questions may need to be asked on whether or not the particular legal framework is sound, considering that recommendations had been made so long back in time. Is effective oversight dependent on effective legislation? Alta certainly thinks so. I would just like to pause here and tie into what Mr. Peter Backer said in his presentation. South Africa is a member of the International Atomic Energy Agency, which is a United Nations agency. We also ratified the Convention on Nuclear Safety in 1996. The International Atomic Energy Agency's recommendations are not necessarily binding, and I wish to put that necessarily binding with an exclamation marks and quotation marks. I will get to that point right now, but this does not mean that the legislator must simply ignore that. I would just like to clarify for purposes of further deliberation in future why the statement is made. And I would just like to reiterate that South Africa is a member state of the International Atomic Energy Agency, and the Convention on Nuclear Safety was subsequently ratified. In the Glenister 2 court case, the Constitutional Court, both in the minority and majority judgments, extensively discussed the status of international treaties and agreements in our law. This discussion can be briefly summarized as follows. Section 231 of the Constitution governs international agreements. The negotiating and signing of international agreements are the responsibility of the national executive. However, the signing of such an agreement does not automatically bind South Africa. For this to happen, the agreement requires the approval by resolution in both the National Assembly and the National Council of Provinces. The approval of an international agreement under Section 231 of the Constitution conveys South Africa's intention in its capacity as a sovereign state to be bound at the international level by the provisions of the agreement, and thus constitutes an undertaking at international level. Failure to observe the provisions may result in South Africa incurring responsibility towards other signatory states. In terms of Section 231 of the Constitution, and it's directed at South Africa's legal obligation under international law, rather than transforming the rights and obligations contained in international agreements into homegrown constitutional rights. Section 231(4) of the Constitution provides that an international agreement only becomes law in the Republic once enacted into national legislation. International agreements, therefore, do not have the binding constitutional force merely because Parliament has approved them. The point I'm trying to make here is that the ball is in Parliament's court in order to make these findings into domestic South African law. Although we are bound to international treaties as member states of various treaties out there, is the onus of Parliament to ensure that this is turned into domestic law. Excuse me, I've just jumping window here. And then speaking of domestic law and issues on a home front, we also conducted a home study, and this home study was conducted by Nathan Gift-Schlapu. Is this report within the public interest? We certainly do believe so. This is also a report that the previous presenter referred to. And the study and focus of this report was, after all, the effective independence of the NNR. This report cost the South African taxpayer approximately 500,000 Rand. That's R500,000. And the apparent completion date for the report, a month's worth of work, was apparently set at 21 October 2013. What these findings were exactly, we are not clear. We were also unable to obtain the findings of this report, let alone see it within the public space. On this report, Alta also wrote to the DMRE in September of this year, requesting a copy of this report. No surprise, we did not receive any response to our request. This is a question to the Portfolio Committee. Has the Portfolio Committee seen this report? Has the Portfolio Committee taken note of the contents of this report? We take cognizance of the fact that this report has been is quite dated, but considering the significance of the potential findings, we would like to state that the Portfolio Committee should seek to obtain this report in the interest of transparency and, of course, in the interest of the independence of the NNR. And then just some concluding remarks following our submission. We state that the bill in its current form is a move in the right direction, but does little to ensure, enforce, and promote independence of the NNR. It is recommended that the recommendations made by the International Atomic Energy Agency be properly considered and or implemented to the extent that it promotes the independence of the NNR. And the NGN report, the Nathan Gift-Schlapu report, be obtained and properly considered and or implemented to the extent that it promotes the independence of the NNR. And just last concluding remark in relation to what may Alta propose changes in the bill, that the powers and functions conferred to the Minister of Mineral Resources and Energy in terms of the NNR Act be transferred to the Minister of Forestry, Fisheries and the Environment. And we believe that such transfer can be achieved through the proper amendment of the definition of the minister within the Act. That is Alta's presentation. We would like to thank the Portfolio Committee for the opportunity to present and for all stakeholders listening to what Alta has to say. Thank you so much.
Thank you, Alta. Honorable members, any take? Going one. Going two. Going three. Okay. None. AFSA.
Good morning, Chair. It's Stumo Shope speaking. Can I share my screen?
Please do.
Just to confirm, can you see my screen?
Yes.
Okay, I'm Stumo Shope, the current Chief Executive of the Economic Intervention Forum of South Africa, which is a group which was founded in 2013 by a group of professionals, engineers, energy specialists, etc. Myself, I'm an electronic engineer by profession, We plan to influence government policy and suggest also interventions that would improve policy formulation. So we read the NNR bill, and in essence, we are happy with the bill. We really approve of it, except there are a few improvements that we thought we should make to the bill, and we went through it clause by clause. Section 1, as you can see on the screen, on the left-hand side of the column, we have what is written in the current bill. We have our proposal in the middle, and then any comments to that proposal. The first one, we thought it would be prudent to have licensing of personnel and actually have a SAQA unit standard, because when we looked at international best practices, there are specific qualifications for nuclear personnel which we do not have in South Africa. So we thought that would be important to add. And on 1ND, there is a mention of a nuclear reprocessing facility. Our view is that maybe that should have been a nuclear fuel reprocessing facility, because we thought that it talks more to the reprocessing of the nuclear fuel. 1NL, any facility, there was nothing mentioning nanotechnology and nanomaterials, so we thought maybe that can be added to the wording along the list of the materials which are mentioned there. And also in 1Q, there was the exclusion of uranium-238, which is radioactive, although not as bad as 235, as well as thorium. As thorium is now an emerging a nuclear fuel. There are many nuclear reactors which are being built currently, which use thorium as the fuel. On 7B, is it 7B? That one has to do with actually the board. We agree with the NNR that, and we propose that the removal of organized labor, the removal of organized business, the removal of community members from the board. At any case, the issue of a person affected by nuclear activities is very broad, and therefore that is very site specific. And to answer the question of Honorable Maina as to how the concerns of the public will be taken into consideration, we believe there are sections of the Act such as 76A and B, and section 22(2), which talks to the inclusion of societies, and there are processes in application where the people who are affected by the site or where the site will be established, they are consulted. So we believe they do not have to be in the board. There is adequate space for communities to make inputs. And also, we looked at regulators like SAPRA, NERSA, ICASA. There is no organized labor, there is no organized business, there is no civil society. So we are pushing for alignment. It's a regulator, it's not an operator of the facility itself. And on the number of the board members, we believe the number of the board members can be further reduced. All you need is the skill, and the number does not necessarily improve the skill set. And it is weird for some of us that you can have a board which is much larger than the executive of the organization which does the actual work. The board does not necessarily does the actual work, it does oversight. And also the chief financial officer, we do not say why the chief financial officer should be on the board, as this is a Schedule 3A entity and financial performance is not primary. Sound financial discipline according to the PFMA is required, and the CFO can always be invited to the board to make a presentation, but it shouldn't be legislated as far as we are concerned. And the next one is 7JA. The persons who are suitable to be on the board, we believe we should also add nuclear safety specifically, because on the list, nuclear safety is not there, only nuclear science. So we believe you should also add nuclear safety. And on 11F, on the chief executive officer unable to perform his or her functions, the current clause only talks of a temporary, and we believe there should be a section, an addition B, where the CEO is either permanently removed or for whatever reason is unable to do his job permanently, then that subsection should be added to cater for that permanent inavailability or inability to do his job. And in the issue of acting, we believe there should be a limit to the acting of a chief executive officer, because we have seen a lot of damage done by acting chief executive officers over extended periods of time. I remember, for instance, the AMSCO chief, there was an AMSCO chief, acting chief executive officer for a period exceeding 5 years. And that is actually the term of a chief executive officer. So it is not ideal to have an acting chief executive officer over extended period. Also, we thought on section 1711, there should be a time limit to respond to the license application instead of leaving it open-ended as it is at the moment, so that there is some agency. A license applicant does not submit an application and then it stays in limbo for an extended period of time. Section 18B2, we think there was an omission there because the clause basically ends in mid-A, that the chief executive officer must direct that the applicants for a certificate of registration, of exemption, authorization to design or authorize to manufacture, and then in the current text, that's where it ends. And then we got those things that must be submitted from the current act. So we think there was just an omission there where some things fell off the desk. On section 19.2D, we thought a reason based on objective data and evidence to be provided for impositions of restriction. At the moment, the restriction can be imposed, but there is no obligation on the regulator, I think the CEO, when imposing those restrictions, to provide data as to why he imposed those particular restrictions. We are doing that in order to avoid arbitrary restrictions being imposed unnecessarily. 22(1)(d) speaks about training and information to staff. We just want to add that it should also explicitly include nuclear safety, because training is a generic and we are dealing here with a nuclear regulator. And we are adding 22(l)(j) that the operator must be compelled to maintain a register or a log of staff training and evidence of the implementation of self-inspection programs, because there is a requirement to have a self-inspection program. So there needs to be an explicit regulation or rather a specific requirement for maintaining a register of training as well as the self-inspection program. It can either be in the Act or in regulations which are issued by the regulator in order to make sure that there is audit trails that things were indeed done. And 23, if I remember 23 well, it talks about the financial resources for rehabilitation. What we found is that it is not clear in what format will the regulator ensure that the operator has the financial resources for rehabilitation. Are they going to have an escrow account, etc., etc.? This is especially important because nowadays, if you talk of SMRs, for instance, the lifetime of an SMR can be up to 60 years. And then someone must make sure that over that 60-year period, there are those financial resources for rehabilitation at the end of the 60 years. So some way, either in regulations issued by the regulator or in the Act, it must be clarified. How are we going to make sure that we audit and we check on a regular basis that those financial resources are there? And then on section 26, where the minister must categorize various nuclear installations or facilities according to their potential for and consequences for risk. We believe there's no need for the Minister of Finance to be there, as this is purely a technical risk assessment process. So it must only be up to the Minister of responsible for energy. In the previous law, there was no Minister of Finance, but that has been added in the bill. We believe that should be removed again. And the only time the Minister of Finance comes in to make input is on the quantum of how much must that financial security be based on the categories. To say, for instance, if it's category 1, it should be $100 million or 500 million rand. If it's category X, it should be that much. That's the Minister of Finance in consultation with the Minister of Energy. But as to the categories, it's a risk technical assessment, and that should be left alone to the energy and nuclear specialist. And on 23, if I remember 23, it had to do with the the transfer of materials. The transfer of materials from one person, from one license holder to another, and therefore the transfer of liability for that material. There is no mechanism in the bill that explains how the transfer of how that is controlled, and we hope in the regulations that will be developed that will be clarified. As well as 27 for the accreditation of transporters and their compliance conditions, because there should be only accredited vetted transporters to transport radioactive material. And we believe there should be a regulation which is developed by the NNR, for example, on the transport and packaging of radioactive material. We looked on the NNR website and we did not find any regulation about the transport of radioactive material. What we found in one of the people who do transport is that they refer to the International Atomic Energy Agency regulations, which is a bit problematic because you end up with a secular reference because if you go AEA regulations, they only tell you about what the regulation aims to achieve, and they clearly state that we cannot prescribe in details because that depends on laws inside the country and regulations. So it is up to the regulator in the country to develop such regulations. And we also checked in other jurisdictions. We checked in India. India has a very detailed regulation on packaging and transporting of radioactive material. The US in the 100 CFR regulations, they've got very detailed regulations on how to transport and package radioactive material. And we feel that the NNR should be compelled to develop regulations for the transport and packaging of radioactive materials. And then on 33dB, we have a problem with the issue of DIMS fit. Or it thinks, I do not remember which one is the latest valid one, but DIMS fit, what we believe is that it should be based on an objective assessment. Otherwise, if DIMS fit is too subjective. 34B1, where a possibility exists that a nuclear radiation accident or nuclear or radiation incident affecting public may occur, the regulator must. We think it should be made more objective. It should be determined by a risk assessment of that particular installation. Otherwise, you end up again with a subjective assessment of a person at that point in time. And this was 35F5. It deals with, in the case of an incident, we believe there should be a mechanism to track the names, identity numbers, contact details of next of kin of all persons on the nuclear facility at any one point in time. That is not in the text of the bill. We just think that should be added in the bill, and that should be integrated as part of the emergency preparedness plan of the operator. And 41 is about the inspectors. The training and certifications should be strengthened. In our opinion, it is open-ended in the law, but if there are regulations, it should be made more strict. And then section 42 is about the disclosure of information. We are of the opinion.
You are now on my 3 minutes discretion.
Thanks, Chair. We believe that section should be removed completely. The justification there being that state security information is handled according to the Protection of the State Information Act, which is implemented through the MIS, and for defense, it's implemented through the Armscor Security Instruction AWI 14, and therefore that section we believe is redundant, and it can cause confusion as to which act is precedent. So it is best just to remove it. It does not add value, it adds confusion. Incidentally, in yesterday's NASA session, I think I would have made the same comment about that section, because that bill also has the same information clause. So a removal is suggested. Thank you. Thank you, Chair. Thanks to the committee and all participants.
Okay, thank you, sir. Honorable members, is there any questions of clarity that you would want to pose? Going one, going two, going three. Sir, I just wanted to check one thing. In your understanding, because one might say there's a contradiction that you talk of over-regulation, but at the same time, you might be interpreted to be suggesting more regulation. If you say there must be a prescription, I hear the issue of the CFO and other things, but I think that one can be tackled. And whether that it is relevant on the enforcement, again, it depends what is the objects of the bill. We have to look at whether that's it, but let's follow what you have just made. Would someone not be interpreting as over-regulation if you even regulate the time of an acting period, but also would that not be interfering with normal, let me use the word in inverted commas, normal labor relations processes? For an example, the issues of how long a person can act and the CEO may be contained in the PFMA. There are laws that governs that, but also there are labor relations where it might say a person can act for more than 6 months or 3 months, it depends. It must be rotational. Some might say, the policy says there must be rotational. There could be internal policy. But the other one would say, what if in that period we have advertised and we can't get the appropriate candidate and we have to go back? Would that not be too prescriptive on the period of an acting CEO and why it should be distinct to other positions? I think if you can clarify that thing so that the committee does not enter a terrain where it is now even prescribing the employment policy which is unique to the entity. I get the issue of an acting for 5 years. One might argue and say, but it is not as a result of the police or the lack of police. It is the lack of effective executive management. That is why that thing could go to that extent. If people don't perform their duties for a period of 5 years, they can't even employ a CEO permanently. It actually says they failed in their fiduciary duties. So exercising executive authority would have been the challenge, not that the law does not provide for that. What would be your comment on that?
I think, thank you, Chair. I think the overregulation, you may be right there. Maybe from where we are sitting, we are frustrated. Maybe it was out of frustration that this goes on way too long in our state entities, resulting in them being ineffective. Because many will agree with me that an acting CEO sometimes does not feel that he's got all the mandate to execute his job, because he can be removed anytime from his job. He is, after all, acting when his principals suddenly do not agree with what he is doing. Maybe it's out of frustration. Yes, it's overregulation, but it's out of frustration. I think there we align with the CEO of NNR to clarify the role of the board in appointing the CEO of the entity. From where I'm sitting, I completely disagree with the current processes. The CEO is accountable to the board. The board must appoint the CEO, and the minister must be out of it. That is my view. So
Okay.
The current setup doesn't work. So maybe it's frustrating from our side. Thank you.
No, I just need the clarity so that we know. So sometimes there could be terrain that, for instance, some of the issues that are in line with what the Public Service Commissions Act says. Maybe that's why the things must be fixed on. There are things like your King, I think it's King 4. Yes,
no.
King 4. Yes, King 4. So generally, I'm asking this question so that at least for us also as a committee, we know to what extent, what parameters can go. I take note also on the issue of the appointment. I think, again, like you say, it is something that we have to clarify ourselves as members. Because, like you say, in other areas, the appointment of CEOs is done by the board, obviously in consultation or in concurrence with the minister. But in other cases, the appointment of the CEO is done by the minister. So I think it's something that for us as a board, I'm saying as a committee, as we move forward, is whether it's a terrain we want to go in or we want the law to prescribe in terms of public service commission what is supposed to be the real, not the ideal, the real situation as far as that is concerned. Okay, thank you very much. Is it say Aves? Yes,
Aves.
yes. So okay. Ari, who is next?
Safche and Elache.
Okay. Can they come in? They see their time.
Thank you very much. May I share my screen?
Yes.
It says that the host has disabled participant screen sharing. Can it be enabled, please?
It is enabled.
I just saw something says in the screen assigned.
Okay, maybe it's been assigned now. There we go.
It's the network between you and the sender or the person who's giving it. That's it.
Well, it's now working, so thank you for that. Whoops. Yeah, well, thank you very much for the opportunity to make this presentation to the committee. My name is Adrian Pohl. I'm an attorney representing the South African Faith Communities Environmental Institute and Earth Life Africa Johannesburg. Just to say that, yeah, we've been without power since 2:30 this morning, so if I drop off, I do apologize for that. It would be because my backup supply falls off. I will be followed in this presentation by Andre Naidu, who will make some further submissions on behalf of SAFC and possibly by some Earth Life members. Just very briefly to start, SAFC is a non-profit organization established by multi-faith environmental and social justice organizations to, inter alia, or amongst other things, confront environmental and socio-economic injustices, support faith leaders and their communities in Southern Africa to take action on eco-justice, sustainable living and climate change issues, while Earth Life Africa Johannesburg is also a non-governmental, non-profit voluntary association established by environmental and social justice advocates to mobilize society around environmental justice issues in relation to people. Earth Life works to promote local and global environmental and social justice issues on sustainable energy and climate change issues. Just briefly to start, prior to making comment on this 2023 bill, SAFC and Earth Life submitted written representations to the DMRE on the first NNR Amendment Bill in 2021. Those representations focused on provisions that, in the view of the organizations, would weaken nuclear safety governance. Just to start out, on the 2023 Amendment Bill, it does contain some improvements on the 2021 version, including that sections 10 and 11 are no longer being proposed for repeal. Those sections address meetings of the board and in particular minutes, the requirement for minutes to be kept of board meetings, which is obviously important. We also note that the category of persons who may make written representations on Section 21 licensing applications has been broadened from directly affected to affected persons. We note that the commenting period on Section 21 licensing applications has been extended to 90 days, and that the period within which to appeal to the High Court in respect of a decision of the NNR board has been extended from 60 days to a maximum of 180 days. We also note that sections 35 to section 35 sub 10 specify factors that must be taken into account in preparation of emergency plans and issues to be included. I'm not sure why this is in the way. Don't know quite how to get rid of that. Included in such plans. Regarding concerns that the organizations have relating to the current amendment bill, and of course the NNR Act that it seeks to amend. The first one, we're obviously not going to deal with all concerns, just some of the highlights. We have submitted written comments as well. The first issue is that the nuclear authorization holders will be able to transfer authorizations to a third party, which is obviously a new provision. It's currently prohibited. Part of the problem with this is that upon transfer, the original authorization holder's period of responsibility ends, and there are no conditions or criteria specifying that the original holder would remain liable for nuclear damage arising later due to design or construction flaws, or that the original holder's financial security should remain in place. So the concern there is obviously if a certain organization or company builds, for example, a nuclear power plant and subsequently transfers it to a third party, and later on, due to either construction flaws or whatever, or design flaws, a catastrophic incident occurs, that original holder would not be responsible for that. As we pointed out, the holder is only liable for nuclear damage that occurs during its period of responsibility, and we don't believe that it's reasonable or rational, that it's a reasonable or rational legislative measure designed to protect the public property and the environment from nuclear damage, which is, of course, the main purpose of the NNR Act, as alluded to by some of the previous presenters. Another concern is that the regulator is empowered, if this amendment bill goes through, to permit pre-construction activities to prepare a nuclear facility site. The concern there is that such pre-construction activities, which can be quite extensive and involve a significant investment of finances, could occur before a nuclear authorization or nuclear license is granted, which could in turn potentially sway licensing decisions. Other concerns relating to governance is that the proposed amendments will also empower the minister to make regulations on developments surrounding a nuclear facility after consultation with, in place of in consultation with relevant municipalities. The change of those words means that they won't be required to obtain the concurrence of the municipalities who may be affected, but would only be required to consult with them to seek their views. We feel that is a problem, given regard to the fact that this would fall within concurrent constitutional jurisdictional areas, and obviously could have an impact on in particular municipal planning. The organizations also have some concern over the removal of the requirement for vessels carrying nuclear materials to obtain authorization to enter South African waters. Basically, the bill makes provision for that to be authorized through the nuclear authorization. And then another concern is the removal of the obligation on the minister to table within a specified time frame an annual public report on health and safety matters relating to workers, the public and the environment, which would seem to undermine Parliament's constitutional oversight function. The requirement is still in place to submit an annual report.
Is it on my side where I'm lost?
No, Chair.
Is it Adrian?
I think it's from his side, yes, Chair.
It's disappeared.
Yeah.
What do we do?
Hi, good afternoon, members. If Adrian's connection has gone lost, myself and Kitse Paone can continue with the presentation if needed.
Continue. As long as the
Okay.
presentation is on the screen.
Yes.
I don't know what happened.
They haven't
now.
sent the presentation to me, Chair. Otherwise, I could have flighted it.
Okay, let me just see where he left off. I believe he left off on governance issues. Then we can, if we just allowed to get our screen to be shared, that would be lovely.
I've given you co-hosting rights.
Thank you. Let me see where he left off. Can everybody see my screen?
Yes.
Yeah.
Okay, so I believe it was highlighting the governance issue. So I'll just read and then try and expand on what I can. So he said nuclear authorization holders will be able to transfer authorizations to a third party, meaning original holders' period of responsibility ends, and no conditions or criteria specifying that the original holder remains liable for nuclear damage arising later due to design or construction flaws, or that the original holder's financial security should remain in place. Any holder is liable for nuclear damage during its period of responsibility, and not a reasonable or rational legislative measure designed to protect the public property and environment from nuclear damage to remain from nuclear damage, meaning the main purpose of the National Nuclear Regulations Act. The regulator empowered to permit pre-construction activities to prepare the facility site. That is also a bit of a governance issue because it's prior to many of the activities that will be taking place. And then continued, the proposed amendments will also empower the minister to make regulations on development surrounding a nuclear facility after consultation with, in quotation marks, in place of, in consultation with relevant municipalities. In other words, the requirement to obtain concurrence of affected municipalities will be removed, which is a big governance issue. Secondly, it will also remove requirements for vessels carrying nuclear materials to obtain authorization to enter South African waters, meaning that if transport is authorized in a separate nuclear authorization. Thirdly, removal of obligation on the minister to, within a specific time frame, table in Parliament an annual public report on health and safety measures relating to workers, the public, and the environment. And this undermines Parliament's constitutional oversight function. So there will be no oversight with regards to health and safety matters as related to nuclear energy and related issues. On the next issue raised is the public participation aspect. Proposed amendments do not address important shortcomings in the current NNR Act relating to procedurally fair decision-making. This includes no requirement to give interested and affected parties written reasons for refusal or approval of a nuclear authorization, so no communication, no provision for notice to public comment or for written reasons to be provided, IRO. Proposed submissions of the current prohibition of the transfer of nuclear authorizations with provision allowing transfer with written approval of the NNR CEO and pre-construction activities that may be allowed prior to written permissions from the regulator. So this denies access of public to make comments. And then the DMRE should take this opportunity to align the NNR Act properly with the Public Access to Justice Act and the foundational constitutional principles of accountability, responsiveness, and openness, and to make provisions for meaningful and informed public participation in the decision-making processes. Next, we go on with strict liability and limited liability. The current NNR Act and proposed amendments provides for strict liability of the holder of a nuclear license for nuclear damage caused or resulting from the nuclear facility during the holder's period of responsibility. But there's also limited liability. In other words, liability for nuclear damage is limited for each accident to the amount that determined in Section 29, Part 2. So there's a difference within the liability measures. If total claims of compensation will exceed the amount of security provided, the minister is obliged to table a report recommending to Parliament that it appropriate funds for rendering financial assistance to the holder, and secondly, by notice in the Gazette, suspend the obligation to pay claims until Parliament has made this decision. So that's some governance issues as well. And then the level of security based on Category 1 nuclear installation is approximately 3 billion rand, and the cost of Fukushima's is 9 trillion rand. Will the polluter pays principle be applicable here or not? That is the main question regarding that. And then with regards to the disposal of high-level waste, the proposed amendments is inserting a definition of disposal as meaning the emplacement of radioactive waste in a disposal facility without intention of retrieval. And it substitutes the definition of closure with a new meaning, namely the completion of all technical and administrative operations after the disposal of radioactive waste. Now, this is also just minimizing some responsibilities with regards to the care of the high-level radioactive waste, which may be problematic if this is not addressed. And then currently, unsolvable problems faced by the nuclear industry means there's no permanent or final disposal facilities in South Africa for long-lived and extremely hazardous the medium and low-level waste facility in Amaqualand and in the high-level radioactive waste facility at Koeberg as we speak. The risk that generators could dispose of high-level radioactive waste and placing it in nuclear waste storage facilities, which could in turn allow generators to move towards closure at the end of the life of the nuclear facility in question, leaving the long-term intergenerational obligation to indefinitely store and manage the high-level radioactive waste and eventually find a final disposal solution to the current and future generations of South African taxpayers. So the issue regarding the hazardous waste coming from these things is not being addressed in a meaningful manner, and this will be a burden on not just the youth of South Africa currently, but also our future generations. So this is something that we need to pay focus on extremely. With that, I will end the presentation and I will hand over for comments, but you may also see our submitted comments on the NNR Amendment Bill dated on the 13th of October for any further detail. I thank you.
Oh, thank you very much. I just wanted to, because I never shown my face when I had the challenges. Okay. Honorable members, any questions of clarity? I can't see a single hand. I guess you are free. There is no question that members are interested to ask. Thank you very much for your submissions. You did very well. You have been the best when it comes to time, in as much as you had 2 sessions in one. You left us with 10 minutes. Thank you very much for that.
Thank you very much, Chair.
Okay. Ari, who's next?
The Federation for Sustainable Environment, Chair.
I must come in.
Good morning. I hope everyone can hear me.
Yes, can hear you, ma'am.
Thank you very much. Thank you for the opportunity. All protocol observed. I will start my first slide by briefly referring to the background of the Federation for a Sustainable Environment. There are a number of scholarly papers on the FSE's background and activities. This slide, especially the bold topography, is an extract from a scholarly paper by the historian, Professor Elise van Eden. In line with the extract, the FSE wished to respectfully remind the Honourable Chairperson and Honourable Members of some of the findings and recommendations of peer-reviewed academic and governmental reports pertaining to radioactive mine residue areas not under current regulation. I may just here interpose to state that we have taken grateful cognizance of the NNR's presentation this morning with reference to non-ionizing radiation and the definition of that, as well as the definition of naturally occurring radioactive material, and also including not only uranium mining, but also mining facilities where mining and processing of radioactive ores are carried out. My second presentation is just to explain that our comments are restricted to the sections in the bill which have relevance to radioactive mine residue areas, not under the current regulations, and presumably not under the proposed amendments, that is to measure to reduce the radiation exposure impacts to humans and the environment and to the regulatory process for remediation. Our comments are submitted with diffidence and deference, and I wish to ensure the Honourable Chairperson and members that hyper-scrupulous attention was given to the contents and context of the quotations used in this presentation. Very briefly, the Witwatersrand mining basin had been mined for more than a century. It includes the Far Western Basin, the Western Basin, the Central Basin, the Eastern Basin, the Kosh Basin, as well as the Free State goldfields. And the legacy of the Witwatersrand gold mining left tailing storage facilities containing 600,000 tons of uranium. Tailing storage facilities in which the uraniferous waste is being stored is considered to be the largest man-made structures in the world, and it will stand into perpetuity. It is for that reason that it requires management not only during construction or operation, but also during decommissioning, during closure and post-closure. In South Africa, all our tailing storage facilities, or most of them, are upstream tailing storage facilities, which are considered the highest risk but the lowest cost, which of course imposes the risk of catastrophic failures of tailing storage facilities. Now, I'm going to highlight some of the problem statements, and these are based on academic and peer-reviewed findings from academics and also governmental findings. In these two quotations, it refers to the Witwatersrand tailings and other minor residue as containing significantly elevated concentrations of uranium and its radionuclides, and that mining has resulted in the dispersal of the radioactive material into the environment that is off licensed sites via wind-blown dust, waterborne sediment, and the sorption and precipitation of radioactivity from water into sediment bodies. In 2006, the Water Research Commission published a report titled An Assessment of Sources, Pathways, Mechanisms and Risks of Current and Potential Future Pollution of Water and Sediments in Gold Mining Areas of the Wonderfontein-Spruit catchment, in which it found that the measured uranium content of many of the fluvial sediments in the Wonderfontein-Spruit, including those of mine properties and therefore outside the boundaries of licensed sites, exceeds the exclusion limit for regulation by the National Nuclear Regulator. I here also wish to interpose that the Wonderfontein-Spruit catchment falls within the West and Far Western goldfields. It's extensively used and is densely populated. It's used for spiritual rituals such as baptisms, irrigation, watering of cattle, recreational use, domestic use, and at times also for potable use as a result of erratic water supply. This is airborne radiometric images that have been published in the report of the Water Research Commission. The areas in red show elevated levels of radioactivity, especially in wetlands downstream of mining activities. This is a photographic evidence of what is happening currently in the upper Wonderfontein-Spruit and in the headwaters of the Wonderfontein-Spruit. What you see here is the end result of Mintails, Australian mining companies with South African subsidiaries liquidation in 2018. The Parliamentary Portfolio Committee did do an oversight visit of the area in 2018. What was left in the wake of the liquidation of Mintails was uraniferous waste, partially reclaimed tailing storage facilities, unrehabilitated footprints with residual radioactivity, toxic and radioactive dams and wetlands, clusters of open pits with no erosion control, management of dust fallout, stormwater control, access control, functioning tow paddocks and piezometers, pen stocks, and an unfunded environmental liability of 460 million rand. This mining area is in close proximity to densely populated residential areas such as Kagiso. It also resulted in the failure of two of the tailing storage facilities, that is 1L8 and 1L10. and that, of course, then resulted in uriniferous slurry flowing into the Wonderfonteinspruit. This problem has been highlighted by the Parliamentary Portfolio Committee in its report of 2018, where it mentions that mining companies such as Mintails Mining operated without environmental authorization and liquidated with a 460 million rand environmental shortfall, that the state will inherit these liabilities if the mines are finally liquidated. And I just focus on the bold topography. The DMR at the time was told to identify clearly and specifically the gaps between mining insolvency and company law that has led to this ongoing situation where the polluter does not pay. It is the state that ends up paying, and of course the impacts are then externalized to communities. I may also just here mention the loophole that exists in our legislation. The Mineral and Petroleum Resources Development Act places no special obligation on the court to determine whether a company applying for liquidation has applied for a closure certificate, ensured the transfer of environmental liabilities, or actually topped up any shortfall of funds, and the duties and potential liability of liquidators are unclear. Another problem statement is the fact that when the Water Research Commission report was published in 2006, the National Nuclear Regulator disclaimed the findings, stating that it does not align with its own norms and standards and its own methodology, and then proposed to conduct its own investigation and then to make the findings of the investigation known to the public. This resulted in a report titled Assessment of the Radiological Impact of the Mine Water Discharges to Members of the Public Living Around the Wonderfonteinspruit catchment area, and the report found that the past and present discharges of radionuclides into the Wonderfonteinspruit catchment area as a consequence of mining activities, remember it is therefore not on mine sites or licensed areas, can lead to considerable radiological impacts to the public via various exposure pathways exceeding significantly the natural level, and also the dose limit for the public of 1 millisievert per annum at numerous sites. It also referred to the irrigation of agricultural use land and pasture, that causes the highest radiological impacts, that these are off-mine sites, and that the uptake of sediments churned up during cattle watering at the banks of water bodies also represent an important radiological pathway. In augmentation of what was found by the National Nuclear Regulator is a master's student that has conducted studies within the Wonderfonteinspruit. It is titled A Holistic View on the Impact of Gold and Uranium Mining on the Wonderfonteinspruit. And perhaps just to condense the findings, it found that the cattle that water and drink within the Wonderfonteinspruit, as well as grade within the Wonderfonteinspruit catchment area, that the uranium levels in their kidneys are 4,350 times higher than the control group. I now continue with the report from the National Nuclear Regulator. It was also found that the irrigation of pasture land and the growth of vegetables and the uptake of radionuclides by cattle due to contaminated pasture soil can lead to exposure pathways. The same report also found that radiation exposures caused by stay on contaminated land and the use of land contaminated by tailings can also lead to high incremental doses. It also referred to air pathways, that is the inhalation and ingestion of contaminated dust, as well as the deposition of dust on crops, which can also cause considerable dose contributions. The same report also referred to the strong dust emissions from slime dams, which continue to this day, and the deposition of this dust then on leaves of vegetable and forage plants. It was then recommended that the National Nuclear Regulator should compile a comprehensive list of short and intermediate and long-term measures concerning the sources of radioactive pollution, and that was done in 2009 when this report was published by the Department of Water Affairs and Forestry, as well as the National Nuclear Regulator. This report found that 36 radioactive hotspots within the Wonderfonteinsspruit had been identified, and some of these sites that fall into category 1, there is no reason to delay immediate action. The Lancaster Dam was considered the most urgent, and that there is an immediate requirement for a clean-up of these actions. I can now assure the committee members and the Honourable Chairperson that from the physical evidence or the real evidence evidence can be adduced that this has not happened. This report was published in 2009. Other academic reports and governmental reports also referred to the pollution that can enter into areas that are not under licensed sites, and the pollution sources are radon and wind-blown dust, the waterborne pathway, ground and surface water, or due to direct access where people are contaminated, or externally irradiated after unauthorized entry to mine sites if there are no access control, or by living in settlements directly adjacent to mines, or in some cases living in settlements on the contaminated footprints of abandoned mines. This is a case in point. This is Tudor Shaft informal settlement. According to Professor Dorothy Tang of the Hong Kong University, there are approximately 20% of the population in Johannesburg and in Ekurhuleni living in informal settlements, approximately 400,000 people in the mining belt. Now, that also aligns to the findings of GDART, Gauteng Department of Agriculture and Rural Development, in terms of these two reports that have been published, where it found that approximately 380 mine residue areas are in Gauteng, and most of these are the residues of gold mining, so outside licensed sites. And the bottom bullet point, it stated that the majority of mine residue areas are radioactive because the Witwatersrand gold-bearing ores contain almost 10 times the amount of uranium than gold. In this map, you will see the red areas indicated where there are mine residue areas, and it is densely populated. It was also found in the GDART report that another matter of concern is that the radioactive tailings coexist in these mine residue areas with the iron sulfide mineral pyrite, which of course results in acid mine drainage if it combines with oxygen and water. And this acid solution is capable of dissolving and mobilizing the naturally occurring radioactive metals, and this of course can result in serious pollution within the region. A very common practice within these legacy sites or mine residue areas outside licensed sites is the use by children and pregnant women. They use it either for dermal cure or alternatively to eat. It's a practice called pica or geophasia. It's also used for recreational activities, as can be seen in these photographs, residential developments, as well as hunting purposes. It's also used for swimming. Stormwater runoff from these tailing storage facilities containing uriniferous waste. The water is then ponded in these tow paddocks. The water contains a wide spectrum of metals, including uranium and its radioactive progeny. And children, this is a photograph in Soweto, are using the water for recreational purposes. The tailings are also used for construction material, and it was found by the Council of Geoscience that there has been a historic migration of generally elevated radioactive levels to the urban areas of Johannesburg Central Business District, indicating the use of dump and waste material for building purposes, as well as downstream plumes in wetlands areas. I now wish to briefly refer to the site visit that I was requested to conduct for the United Nations Special Rapporteur on Toxics and Human Rights, Dr. Marcus Orolana, on the 2nd of August 2023. In his mission statement, which he presented in Pretoria on the 11th of August 2023, he stated that South Africa faces the crude legacy of pre-1994 environmental racism. He stated that the legacy of pervasive air and water pollution to this day, and I here also interpose uriniferous waste, is disproportionately impacting upon marginalized and poor communities. The last statement, the last sentence in this slide, overcoming it, he said, will require significant additional efforts, including structural, legislative, economic, and environmental challenges. The NNR, of course, did produce a plan for remediation of contaminated sites in 2015, that's 8 years ago, in which it stated it is now time to attend to the areas where contamination exists but which are not under active operation. Also called for existing exposure situations. Some of these areas are currently used for residential dwellings or for farming activities. The National Nuclear Regulator Act of 1999 is undergoing a revision to include these historical contaminated sites under its ambit. We are unaware if this is included in the amendment of the National Nuclear Regulator's Bill. It also produced in 2015 the remediation criteria and requirements. In terms of this position paper by the NNR, it stated that the current National Nuclear Regulator Act and its regulations do not adequately address remediation of existing and emergency exposure situation in relation to naturally occurring radioactive material. It has become urgent to bring these contaminated sites under the National Nuclear Regulator's authorization and to establish rehabilitation criteria.
Okay,
we
ma'am,
are
let me, as you enter my last 3 minutes option time, it's okay.
Thank you. I just want to also mention that the South African Human Rights Commission has also called on the National Nuclear Regulator, and I'll just read what they called upon. They found and directed the National Nuclear Regulator that there is an immediate need to address the lack of clarity concerning the state's roles and responsibilities in the remediation of contaminated mine sites, particularly where such sites had been abandoned. The Commission further finds that in the light of the potentially severe and long-lasting impacts of contaminated sites, the state must prioritize funding for the National Nuclear Regulator to undertake the remediation actions. I will not go into the conclusion, but these are our recommendations and also seeking clarity regarding the certain sections in the National Nuclear Regulator's Bill. But I leave it to the honourable members and also the honourable chairperson of the Parliamentary Portfolio Committee to peruse this, because I have made my presentation available to the committee prior to my presentation. I thank you for the opportunity. Thank you.
Thank you, ma'am. Honorable members, any questions of clarity? Okay, going 1, going 2, going 3. Can we take the next one, Ari?
Project 90, Chair.
Are they in? Going 1, going 2, going 3. Who's next after them?
Natural Justice, Chair.
Are they in?
I saw some representatives, Chair. But yeah.
Good morning, Parliamentary Committee members. I am here representing Natural Justice on behalf of my colleague.
Okay, continue.
May I please share the screen? Chairperson, may I please share the screen, my screen?
You've been given co-hosting rights.
Aras is doing that. Ari, can we agree or can we work on this? Ne?
Yeah,
Check
no, we
the-
sort it, Chair.
Yeah, please try to sort that so that we just kick in.
Sorry,
Okay,
honorable
you-
members, can you see my screen?
Yes, Alan.
Okay, thank you. Good morning, Chairperson, and good morning, committee members. My name is Alan Basajasubi. I am from Natural Justice, which is an environmental human rights organization, Lawyers for Communities and the Environment. And we thank you for the invitation to present some of our comments to the bill. I've prepared a short presentation to just go through some of our comments and concerns with regards to the bill, and I will begin shortly. By way of introduction, I would just like to point out some of the comments or give an overview of the introduction of this particular session in which I'm presenting on. We will be reflecting on some of the concerns with regard to the bill, and obviously in light of the context in which it is being discussed. Just to point out that at the moment, we know that uranium, which is a fundamental component of nuclear energy, is a carcinogen, which is obviously dangerous to human beings. And where there are catastrophic events, these present unsafe levels of exposure to human beings. And so the presentation of nuclear energy does come with significant risks. And just to note that some of these contamination risks cannot be completely avoided. We obviously understand the regulation and maintenance role of the DMRE in terms of managing waste removal, but we do know that sometimes there's never sufficient regulation of radioactive material. We also know that some of the regulatory systems in which the DMR operates does not remove the increasing risk to potential impacts of waste and nuclear catastrophic events. And we know that on the history of the rehabilitation of the mines, for example, that there are a number of different mines that have remained unrehabilitated, which have exposed the communities and the environment to risks. And so we understand with the need to consider nuclear energy that presents potential risks to the public, the health and environment. And so the question then becomes, does nuclear energy present a reasonable option for energy, given that the country and the world is currently discussing pathways to renewable energy and just energy transition. So the question remains, should we be considering nuclear energy in light of the call for a just transition and the consideration of other zero carbon emissions? Moving on to my next slide, just to make a couple of general comments. The evidence and the economics show that nuclear energy may not necessarily be economically viable in today's context, and it may not sufficiently meet the requirements of job creation. There is also questionable evidence as to whether nuclear will provide enough energy security and access. That is within not only city centers, but also in the rural areas. There are also significant environmental concerns that come with nuclear energy. And so given the fact that renewable energy is at the moment, according to economic evidence, a much more cost-effective potential energy resource, any movement towards nuclear might undermine any process to taking on renewable energy. And so we also question the extent to which the regulatory system by DMRE and the power in which the minister would have would potentially undermine any potential upkeep and upscale of renewable energy. And so we do remain concerned around the track record of the DMRE in terms of its rehabilitation, and also the extent to which the bill makes provision for liability, which should not be limited. Moving on to my next slide. So let us begin with discussing whether nuclear energy will create energy security. Now, if we consider the fact that the sub-Saharan context, nuclear energy seems to be a presentation for it being within its energy mix. And obviously within the context of the IRP 2019, there is an inclusion of a nuclear energy. However, the economics of nuclear energy are not that they're economically viable, and there aren't any assurances that sustainable jobs will be created. And so the question then becomes whether the planning and the operationalization of nuclear energy is fundamentally needed and desirable. In the context of nuclear energy, we know that the planning to operation times, including the identification of sites, procuring of land, financing, insurance, licensing, building, and the connection onto transmission, can take a long time, sometimes between 10 to 19 years or more. These estimates of duration have increased around the world due to increasing stringent safety regulations. Therefore, making nuclear a solution to energy crisis faced by South Africa will not work due to these long periods of time that will be required to build and establish working nuclear facilities. Further, energy access in rural areas will not be elevated due to nuclear energy being centralized and requiring a reliable grid with capacity. Now, we know in rural areas there's a lack of electricity infrastructure and a connection to grids. However, renewable energy, especially solar, could potentially be a solution for rural areas with no or limited grid access, and can provide decentralized solutions, including mini grids, which are expanding in East and West Africa. Moreover, the installation of solar panels can substitute or delay the need for new electric grid infrastructure, making solar energy a more cost-effective and sustainable solution for these remote regions. Now, there has been an independent research report done by the Stanford in British Columbia, which has stated that small modular reactors potentially create more waste, with more management and disposal being required. Now, the conclusion of the study has been that conventional reactors are better in aspects of radioactive waste generation, management requirements, and disposal options. However, the current IRP advocates for small modular reactors. However, from above, it would be considered economically unviable, environmental unfeasible to consider nuclear energy. Further, nuclear energy power plants will take over 10 years to provide power, which is desperately needed right now. So the presentation of renewable energy sources through wind and solar present South Africa with an opportunity right now to upscale and to provide necessary energy access to people in rural areas, not just in capital cities, but also that can be scaled and address the load shedding issue in South Africa at the moment. Now, the other concern that we have is that nuclear energy from studies is currently expensive. In terms of the Electricity Regulation Act, the objects relating to economically viability are determined as B, an assurance that the interests and needs of present and future electricity customers and end users are safeguarded and met, having regard to governance, efficiency, effectiveness, and long-term sustainability. C, to facilitate investment in electricity supply, to facilitate investment in the electricity supply industry, and F, to promote competitiveness and customer and end-use choice. Now, these particular objects within the Electricity Regulation Act speak to the need of ensuring the interests and needs of present and future generations of electricity customers, and that is to ensure economic viability. However, furthermore, the White Paper on Energy Policy enforces this key objective of affordable energy services. However, nuclear energy is unlikely to achieve those objectives. In the case of the United States of America, for example, studies were shown that nuclear energy was not the cheapest energy option to consumers. In the context of Britain as well, there was a pressurized water reactor, which indicated that the cost of maintaining and ensuring its performance increases from 2 billion euros in 2008 to 8 billion in 2013. The IRP 2019 recognizes that the cheapest supply of energy will be from large amounts of renewable energy. Furthermore, operating costs and competition from cheaper gas and renewable energy sources may indicate that nuclear plants may be unprofitable, considering the fact that the cost of renewable gas and renewable energy resources present an opportunity for the energy costs for customers to be significantly lower than with the operating costs of nuclear energy. Furthermore, the levelized cost of nuclear power, i.e. the cost of building, financing, and fueling all new power plant while removing all subsidies will be relatively high compared to other energy sources. Many of the world's new plants in China, India, and Russia are heavily subsidized in their nuclear industries. And given the fact that nuclear energy has high operating costs, these costs tend to go towards covering nuclear waste disposal. There's also unlikely going to be an increase in job opportunities for local communities because the expertise will most likely come in the maintenance and the removal and the operating of nuclear energy, whereas a small segment of it would result in construction. And most often, local communities do not possess the necessary expertise to work across the value chain within nuclear energy, and therefore a small component of the community or population would be benefiting from jobs. And likely the only jobs that might come from this are temporary construction jobs. Now, on the next slide, I just wanted to share from the report that I mentioned, some of the Global Crisis Nuclear Waste Greenpeace Finance Report, which estimates some of the costs of nuclear waste managers for various countries. We have France, Belgium, Sweden, Japan, United States, UK, and South Africa. Now, take into consideration the items that would most likely feature for costs, you can see costs are astronomical. And so one wonders whether it would make financial sense in today's economy to invest in the long term for security of energy through nuclear energy. The next point is that besides nuclear being expensive, it presents opportunities for posing significant environmental and safety concerns. Nuclear accidents can be catastrophic. Nuclear energy is also not carbon neutral and produces 9 to 25 times more carbon emissions than wind and solar. And given the increasing need, according to the Paris Convention, to reduce carbon emissions, investing in nuclear energy could potentially push South Africa's NDCs beyond the required commitments in regards to its Paris agreements. And so we need to bear in mind the significant environmental and safety concerns that come from nuclear energy. We are also aware that in some instances, nuclear energy requires a lot of water use. Uranium-spent reactor fuel and radioactive waste, which is used to generate nuclear energy, must also be disposed of safely. It can sometimes take thousands of years to break down and will remain dangerous and radioactive to human health. This raises the issues around technical and long-term costs. The time needed also to safely store spent fuel is up to millions of years. The process being used currently to store spent fuel are short-term, with deep geological disposing being the best option. The United States currently does not have a permanent disposal facility for high-level nuclear waste. Therefore, it's also clear that in some instances, the Nuclear Energy Institute has estimated that per megawatt hour, a nuclear power reactor consumes between 1.514 and 2.725 liters of water. This is compared to coal with figures of 1,220 to 2,270 liters per megawatt and 700 to 1,200 liters per megawatt for gas. It's clear to see that just from these brief statistics that the nuclear energy industry relies much more heavily on water than other sectors. A large nuclear power plant may use up to 1 billion gallons of water a day. And for this reason, they are often built next to rivers, lakes, or oceans to utilize these bodies of water. This water consumption is more than what is required for coal-fired power plants by 20 to 83%, with renewable energy being negligible. Now, moving on to the next point is that nuclear generation is inflexible. Now, nuclear energy is inflexible in that it runs all the time, rather than being ramped up or down in response to electricity systems needs. This means it can only serve a set base load and needs to supply power all the time, except for planned maintenance. And this is to ensure base load source of electricity. This means that nuclear is the least flexible power source on grids. Due to this inflexibility, should there be an abundance of renewable energy, it cannot be used, as nuclear energy needs to be used consistently and all the time. A fully reliable and deeply decarbonized electricity system must include technologies that complement and buttress renewable energy such as wind and solar capabilities. Where it is being used as a base load, that undermines the integration of this renewable energy in moments where energy is actively needed. Now, with regards to the next issue, that relates to the risks and concerns with the unfettered powers and controls of the minister in regards to the bill over nuclear energy. In terms of the bill, the Minister of DMRE has extensive powers in making decisions on issues of nuclear energy. The Nuclear Energy Act 46 of 1999 makes the Minister of the DMRE the regulatory authority over nuclear security and safeguards. The National Nuclear Regulatory Act, in some sections, allows the Minister to act after the consultation with the Board of National Nuclear Reactor. This, however, has been amended with the idea of it being a recommendation from the board, as in section 2C, 2F, 11A, and 11B. What this means is that following the amendments to section 49 of the National Nuclear Regulatory Act, the minister is the final decision maker, especially in instances where there are disagreements between the board and the minister. And therefore, if in any instance in which a recommendation is made, the minister is entitled to make a final decision whether or not the recommendation that is given has been
You are on my 3 minutes of reference optional time.
Sorry, Chair?
You are on my 3 minutes reference optional time.
Must I conclude now?
We have 3 minutes to conclude.
Okay, let me go to my conclusions. Thank you, Chair. In concluding, the protection and the respect of public participation and access to information and the ability to test decisions of government and its ministers must be recognized in this act. And we need to pay cognizance to the white paper on renewable energy policy, which makes a long-term vision for sustainable, completely non-subsidized alternatives to fossil fuels, which therefore promotes and advocates for the use of wind, solar, and small-scale hydro energy. Given that the consideration of renewable energy may potentially undermine this energy mix, which needs to ensure that South Africa transitions to net zero, given its Paris Agreement commitments. Thank you, Chair.
Okay, any comments, honorable members? Going one, Honorable Mylem. Going two, going three, you are the only hand present here, Honorable Mylem. Come in.
Thank you very much, Chair. I just want to understand that I've captured this correctly, that the primary objection to this bill is ideological in nature, that you are opposed to nuclear in general, and that the specific issue that you take is the minister's heavy-handed authority that is granted in this bill, if that's my understanding. Can you just clarify that for me? Thank you very much.
Thank you, Honourable Member.
Wait.
The reflections are accurate to the extent that it...
Can you wait, Alan? Can you wait?
Sorry?
So that you give one answer. Can you wait? Just, I think, in addition to what Honorable Mylem has just raised, because we are amending an existing act, which is, we're amending a law. Now, you have to assist and guide us in terms of what is proposed on the amendment of the law, so that we don't take for granted we know what you say. Are you suggesting, for instance, based on the examples, that instead of amending the law, bring in a law that forbids the use, so that we straightforward with this, that bring in a completely new law that forbids or prohibits the use of nuclear as a source of energy? I just want.
Thank you, Chair. May I come in?
That you've got an existing law that the department says it has to be amended. And I don't want to assume that you are saying there's no need to amend the law. You just need to repeal it and make it a point that the use of nuclear is forbidden, or it is not allowed as a source, as an alternative source of energy. So if you can answer, you can just add that in your response.
Thank you, Chair. May I respond?
Yes.
Oh, thank you. Thank you, honorable members. Yes, to be upfront, natural justice is in opposition to nuclear being a resource that is considered as part of the energy mix. And so our position is that the nuclear energy is not needed nor desirable, taking into consideration the call for a phasing out of fossil fuels, including nuclear energy. And we propose that we remain committed and focused on upscaling renewable energy, and rather developing legislation that scales up and ensures that renewable energy is brought online. And this flows fundamentally from the risks to the environment, the risks to people, and the potential risks that it might have in regards to ensuring that the right to a healthy environment is protected. And so fundamentally, from an environmental and human rights perspective, we are opposed to the need to consider renewable nuclear energy. And in terms of the issue that was raised by the DA member in regards to the unfettered power, that is also another concern that we have in regards to the act itself, which might undermine potential progressive recommendations that the committee might make with regards to recommendations to the minister, which might potentially be abused in situations and could have significant impacts on the rights of people and the environment. And so for us, our categorical position is that we don't consider nuclear energy an option to consider. Rather, attention should be made towards developing and upscaling a reformation of legislative frameworks that look at renewable energy. Thank you.
Okay, thank you very much. Ari, who's next?
We are finished, Chair.
Huh?
We are finished.
Good afternoon, Chair.
Hello.
Hi, it's Project 90 here. We had some technical difficulties earlier on, and I've sent an email to Ariko asking if we can present after natural justice.
But the procedure is that if you do, when did you send the email?
Just before natural justice came on.
Okay. But please, next time when you are in the portfolio committee and you encounter, it has to be done immediately, so that the committee does not amend its own program. We are avoiding things that in future can put us in trouble and say you did a favor to this one, but you never did this favor to this one. But you can come in.
Thank you so much, Chair, and my apologies again. Thank you so much. I'll share my screen now.
We can see the logo. Maybe the presentation is going to come in now.
Yes, thank you so much, Chair, and I greet everyone, including the Portfolio Committee, the Chair, and members of the Portfolio Committee, as well as everyone on board. My name is Lydia Peterson, and I am presenting now for Project 90 by 2030, and leave it there. Okay, so Project 90 by 2030 is a social and environmental justice organization that aims to inspire and mobilize society towards sustainable development and equitable low-carbon future. Our mission is to bring about significant positive change in the way we as humans engage with Earth systems and each other. We support the involvement of all South Africans in a just transition. So our comments, we welcome the following changes to the amendment bill: the clarification of certain definitions and insertion of new definitions, and the fact that the serving time of the directors appointed to the board have been extended from 3 to 5 years to allow for continuity of the work. We, however, have 3 major governance concerns. Concern 1 is the conflict of interest. The minister responsible for minerals, resources, and energy is still in charge of the appointment of the NNR board members. The way this governance structure is currently set up doesn't make the NNR sufficiently independent to make decisions on nuclear safety and to fulfill its mandate to protect the public and the environment. The Convention on Nuclear Safety of 1996 clearly states that the regulator needs to be independent from decision makers on energy and should rather be hosted by the minister responsible for forestry, fisheries, and the environment. And I have noted the comment or the question that Honorable Mileham had in this regard earlier on. And keeping the current governance structure in place is a clear oversight by Parliament. I'm continuing with concern number 2, the Charter and Code of Conduct. In Section 8, it was added that anybody committed to the board must be persons who are committed to the objects and principles as enunciated in the Charter and Code of Conduct of the regulator. The Charter and Code of Conduct are reserved for the staff of the regulator. The same should apply to the board members who are the accounting authority of the regulator. Board members of the NNR should represent different viewpoints to ensure the regulator is fulfilling its oversight mandate. Concern number 3, the community representation. The position of the community representative that is supposed to be part of the board of the NNR has been vacant for the last year. Therefore, we welcome that the amendment bill replaced may with must. With this change, it ensures that a suitably qualified alternate director to act in the place of that director during his or her absence will be appointed. This will hopefully force government to appoint an alternate community representative to represent the viewpoints and concerns of communities in South Africa. Safety concerns. There are issues not addressed by the proposed amendments. Emergency planning section 38 of the Act relates to emergency planning and reads in part, the regulator must ensure that such emergency plan is effective. And this is problematic as it is silent on what action the regulator must take if the plan is not found to be effective. And the NNR has no power in law to compel other government bodies. It is unable to ensure the plan is effective. Indeed, the Act should be amended to bring it into line with international best practices. The public participation concerns. Public participation, Section 21 of the Act deals with public participation, a right enshrined in the Constitution of South Africa. Process as described is inadequate. The Act allows for written representations to the board and then optionally at the board's discretion for public hearings. There is no requirement for any responses to be given to the issues raised during public consultation. Danger that all submissions might simply be discarded and the NNR board could then just tick the boxes that public consultations and or hearings have been done. The Act must be amended to be more explicit about the public consultation process, including that reasons must be provided for decisions in line with the PAJA, as well as written responses to any substantial issues raised during the consultation process. And that is Lydia Peterson for Project 90 by 2030. Thank you, Chair, for this opportunity.
Thank you very much. Honorable members, any questions of clarity? Honorable Malinga, I see going 1, going 2, going 3. That's the only hand that we have. Honorable Malinga.
Thank you very much, Chairperson. And let me welcome the presentation. Chairperson, I want to zoom straight to the slide of concerns that they feel that NNR is misplaced under the Ministry of Energy. One, energy has been considered an energy mix globally since your way back. I think I was not even born. The only time the Department of Environment comes in is when maybe there is a disaster. But this nuclear we're talking about an energy mix. How can people who are dealing with environment then regulate or have a say on what we need to have as an energy mix? I am a bit lost there, Chairperson. If maybe I could be clarified there. What makes that their most concern? Because the only time you hear, like the other presenter, I think he made mention of what happened in Japan, that disaster that happened in Japan. So just one disaster, then it pushes us to put an energy regulator to be under environment. If I could be clarified there, Chairperson. Thank you very much.
Okay, ma'am, can you respond?
Yes, thank you so much for the question. I do appreciate it. As been noted by several presenters here today, is that the NNR is not independent. And it was also noted, I think, with the International Atomic Energy Agency, that they found that there should be a separation. And if we look at a disaster that could happen within at Koeberg, it is an environmental risk. So I do know and I do understand the regulatory framework of the NNR, that it is also in connection with safety. I would say that the Department of Forestry and Fisheries should also play a role here, because it will definitely then affect the environment as well. So our viewpoint is that more clarity or can be given at a later stage within 7 days of this presentation, where we could clarify more on our point where it can fall under that department.
Okay. No, thank you. Thank you, ma'am. Are we now done in the true sense of the word?
That's correct, this Chair. Oh.
Thank
Malinga's
you,
hand was up, Chair.
Honorable Malinga.
Yes, thank you very much, Chairperson. You see, my belief is that, Chairperson, when a bill comes and serves before the portfolio committee, it starts the processes, your cabinet, your network, and what, where every department sits and make their input. I'm not convinced, Chairperson, on that, but I will take it up when we do our own deliberations as the portfolio. I'm not convinced with the response, Chairperson, because seemingly we want to make a law based on what might happen. Are we sangomas here? We're not making a law that is going to assist. Actually, we are amending the law that has been there. And there is no way where, if I read it correctly, that the department, it can be Department of Minerals that brings a bill to the portfolio committee of MRE, whereas it belongs to Environment and Fisheries. But I think it's a discussion when we deliberate on the bill. I'm not convinced on the response, Chairperson. Thank you very much.
No, you are correct. It's a deliberation. Like I said initially, all presenters are allowed to express their views. Members of parliament, when they deliberate, they take those into consideration. For an example, one might argue, that's why I'm saying when we go and deliberate, that will be our platform. That already, when it comes to environmental compliance matters, the Department of Environment, it may not be, and that's one thing that is very critical. The structural arrangement of departments is determined by the executive. Does not mean that environment will always be with fisheries and forest. It might happen to fall somewhere else. But the final determinant of environmental compliance and environmental obligations lies with the department, with the person, the executive responsible for environment. That's where members must then will engage on the discussions, whether the amendments as they are contained now respond to the final authority and determinant, which is the department that is responsible for environment. I think that, to me, Ari, we talked about this thing.
The people who are on this platform, can you go to the chat and
Honorable Malinga, I'm addressing that issue. Ari, we talked about this thing yesterday, and probably we should have laid the rules. There is no need to write on the wall of the committee. And I did say this thing, maybe it's a lesson I must learn, that no one should write on the wall because people are addressing the committee. But if people want to have an engagement with the portfolio committee on their views, they're entitled to do so, to write to the portfolio committee and want to address their concerns with the portfolio committee. So please, let's respect the protocols of parliament. Now, honorable members, thank you very much. And thank you to the presenters that have made their presentations. And the next process now, we expect from an administration point of view, a consolidation of those presentations as reflected since we started. And then subsequently, we will go to the meeting, which is scheduled next week with the Department of Mineral Resources and Energy to get what is their response on the issues that are raised. But before we go to that, there are two issues that Ari will outline that we will also be dealing with, 2 or 3 issues that we'll be dealing with. I hope I'm correct, Ari, on the agenda, either on the second day, depending how far we go.
Yeah.
The first one is the correspondence that has been, it may not be in that chronological order. It's the issue of the, the first one is the issue of the 3 areas that the committee could not conduct public hearings as supposedly on the schedule, which is Zirast Northwest, as well as Free State, Velcom, and Bethlehem. We will present to the committee those issues. The second one is the correspondence with regards to the public hearing that has been received from Makua Amoa. And then the last one is what the committee is expected to do in terms of the proposed program for the first quarter of 2024. Then we will deal with those issues in our committee meeting next week. Did I do the correct justice or did I do justice?
Yes.
Okay.
Yes, Chair. Yeah. So that is scheduled for Wednesday, Chair, after the responses of the department on the ERA bill.
for Wednesday the 13th.
Okay. Thank you very much, honorable members. The meeting stands adjourned.
Thank you, Chair.